Number 492, Clarence Brandenburg, appellate versus Ohio. Mr. Brown.
Mr. Chief Justice, members of the court, we have before us a case arising in the state of Ohio under a conviction under Ohio's Criminal Syndicalism Act. We have indeed before us something of a rarity. It is, as far as I know, the third case ever tried under Ohio's Criminal Syndicalism Act and the first to ever reach an appellate level. There was earlier in Ohio, under peculiar proceedings, in which a prosecutor could bring a proceeding before the Supreme Court on appeal for a question of law only. A proceeding in which a motion was made in the lower court in Ohio attacking the constitutionality of Ohio's criminal syndicalism law. The lower court in Ohio held the law to be unconstitutional. It was appealed to the Supreme Court in State versus Cassay, and in what is basically an advisory opinion, the court stated that it was constitutional. The court also stated several engaging other things. It stated that the First Amendment did not apply to the states of the Union. It also stated that the measure of its application was an issue in its constitutionality, and that it would attend the first trial of a case to see what is the proper measure of its application. The court waited patiently for the first application to a case, and it arose some 40 years later in this case. And surprisingly, despite the invitation sent out in Cassay, the court declined to even hear a constitutional question on the application in this case. It, in fact, defaulted to this court Ohio's privilege of setting forth the limitations of the application of its statute, and Ohio's privilege of setting forth the potentiality of clarification and delineation of a statute which obviously on its face rushes headlong into the First Amendment. These are the facts in this case. A television reporter received a telephone call indicating that if he wanted to, he could come and take movies of a Ku Klux Klan meeting. He came. He met some hooded figures, and arrangements were made for the taking of a movie. A movie was taken in which a cross was burned, some figures milled about and yelled some stupid and rather senseless slogans, and then a single figure was panned in on who made a speech full of conditions, precedents, and reservations, and hyperbola, self-evidently stupid and silly. He asserted that the Klan was the largest organization in the state of Ohio. He then went on with a conditioned precedent that if the various branches of the government, including this court, do not mend their ways, that revengeance, a word of his own coining, I assume, would be taken. He did not specify the revengeance, and we do not know what particular aspect of the democratic process he was going to involve himself in revengeance. He then spoke of a march, not in identifying it as an armed march or any sort of march of any force or violence, into Washington and then into two southern states, incidentally raising federal questions, perhaps rather than internal state questions. Another film taken is inside a house.
There were guns in this first
There were guns in both films.
In both of them.
In both films, there were guns. It is also to be noted that the film was taken on a remote, private farm in which apparently there is no evidence whatsoever that these people were not invitees present on that farm by authority of the ownership of the farm. There was nothing adduced. An indictment was returned after some preliminary maneuvering, including a frontal attack upon the constitutionality of the statute. the case came on to trial. The state produced nothing but the film in question. The only other evidence that the state produced was basically geared to identifying the personnel involved in the film. In other words, showing that the man Brandenburg had a gun similar to the guns in the film, and that he had markings on his person similar to the markings, and that his voice was similar. Other than this, the state offered nothing. It is critical that the state offered nothing on the nature and history of the Klan. It offered nothing showing the course of the Klan's history, any continuing historical or expert opinions concerning any possible commitment to violence. It offered nothing on the continuing organization of the Klan, nothing whatsoever. It offered nothing other than the film itself and the words intrinsic in the film itself. The state then rested. The defense, in which I was not involved, I am a point of counsel appointed for purposes of appeal, made a motion for dismissal at that time. I will frankly admit that the motion for dismissal, which was made by then counsel, was simply a weight of evidence motion, and he did not specifically denote the constitutional question that had arisen at that point in the presentation of the state's case. I suggest that it is completely immaterial that he did not. The defense then proceeded forward and offered basically a defense of depositive testimony in which various officers of the Klan testified as to their ostensible peaceful purposes and things of this sort, and the historical evaluations of the presence of weapons and the burning of a cross. The court then charged the jury. The court's charge to the jury, and I specifically asked this court to consider it carefully, begins in the appendix at page 72, and met with a statute that thrusts itself clearly within the First Amendment, makes on its face no attempt to give us an indication of a line of demarcation between the mere abstract teaching and advocacy, or even advocacy in relation to a clear and present danger as to advocacy in a hypothetical sense. That in no way on its face does this. The court perpetuated the evil of the statute by making a charge even more general, in which he indeed defined the term advocacy as involving intrinsic in it, in his own charge, teaching. So that we had, at this point, a man who had been tried with none of the safeguards of the First Amendment applied to the trial of his cause, to the measure of his evidence, or to the instructions to those who were to be the triers of the fact, which would demarcate a point at which the First Amendment would be operative in relation to what happened on that isolated farm on that isolated day.
That's really great.
How large was this meeting?
The pictures, the testimony, and the pictures indicate that perhaps 20 persons were involved.
Any spectators?
No spectators. All were participants in the meeting. There is some indication of the record that there were no women folk in the picture or in the meeting. There's some testimony in the record that one of the TV reporters said he heard women's voices in another room. I know nothing else about the women folk on that occasion. Pardon, Your Honor?
The film an exhibit?
The film is an exhibit. I pray it is. I have ordered it, and my last word from the clerk was that they were having trouble finding it, but that they would find it and send it on up here. I devoutly pray, because we do have in this case some issues as to what are shown in the film. And
is there a dispute between the parties here as to whether there was or was not a call to engage in violence?
Yes.
There is a dispute.
There is a distinct dispute. It is our contention that there was nothing in the speech, which is part of the record, and shown in the film, and since the state limited itself to this, there is nothing in it that is a call to violence.
And your adversary disputes that.
I assume my adversary disputes that.
The state's whole case was the film plus the identification of the defendant as the person shown in the film. Is that right?
The language of the film is actually in both parties' briefs. The difference between us is that they tend to ascribe certain slogans by the persons milling about to the given defendant. We contend that the only words that the given defendant uttered were the formal set speeches.
This film was shown over a local television station.
This film
and over
was
a
shown
network, wasn't it?
over a local television station and a network.
And a network.
That's correct.
Who was the trial judge?
Judge Simon Lease. Does it ring any bells, Judge?
Yes, it does.
Okay.
Mr. Brown, I gather the indictment, however, was for the events. Is that right? Was the events depicted in the film, not for the exhibition of the film, was it?
That is correct.
In other words, all the film was in evidence was depicting what happened on a certain day.
That is correct.
And it's because of what happened, it was alleged there had been a violation of the statute.
That's correct. The act of showing it over television, which incidentally had intervening parties, the authorities running the television station, are not the basis of the indictment and the charge.
So that I gather, if we're to read the record of the case, we have to see the film, don't we? To know what the proofs were that...
Precisely. As a matter of fact, in the Supreme Court of Ohio, we didn't raise it here because we wanted to see if we could make sure we could get cert. We asserted that the film was in the same position as a book in an obscenity case.
Oh, that doesn't help you.
I know it doesn't help us now, but at that point when we were before the Supreme Court of Ohio, we asserted that, saying that the film in and of itself is the entire context of the alleged offense.
I don't understand your point that nobody but the audience was being, members of the group were being addressed. I don't see the relevance. The reason I ask that is that in the Dennis case, Dennis versus United States, involving the prosecution of communist teachers who taught the Marxist creed, nobody was exposed except the students in the classroom.
May it please the court, there is this important distinction to be made between the Dennis case and that case. In the Dennis case, the teachers who taught these classes, this was evidence within a total context of a total conspiratorial activity leading to a total action result. In this instance, the state contented itself merely with showing a given speech and did not choose to present any evidence to make it part of a conspiratorial whole. It took the speech in and of itself and presented only that.
That's why I asked you earlier. The indictment was for the events depicted.
That is correct.
Not for the showing of the motion picture or in the context of conspiracy or anything else.
That's correct.
It's just what happened on that
What
particular
happened
day.
on that farm on that day.
Yeah.
And that is the important distinction to be made.
Did this appellant have anything to do with arranging for the events to be televised?
There is evidence in the record that indicates that his was the voice that called the radio TV announcement.
Well, if that is so, then it's it's debatable whether this was addressed only to the people who were physically there.
That may be the case, Justice Fortas. But however, the state of Ohio chose not to charge him for that.
If he had arranged for it to be televised, presumably he intended that his remarks reach a larger audience.
It is quite potentially possible. This is, however, not what the state chose to charge him on. Read the indictment.
And if the court could take judicial notice that the Communist Party was conspiratorial, out to conquer the world, why couldn't the court take notice that the Klan was up to no good?
In the Dennis case, I submit that the court did not take such judicial notice. That in the Dennis case, as a matter of fact, there was the adduction of evidence to show that.
I think you may be taking some liberties, counsel, with the record in the Dennis case.
In any event, it is clear that in the Dennis case, there was additional evidence over and above that adduced in this case. In this case, they showed nothing but the film itself. They showed no other plan or purposivity other than
So as far as you ask us to deal with this case as if it was just a group of schoolboys, hooded schoolboys sitting in a room listening to...
That is a potential distinction between this case and the Dennis case as well. These are paltry unknowns, rather silly characters. In the Dennis case, we're dealing with the established leadership of a national organization. This does make a difference in relation to the rights prevailing under the First Amendment. But in this given case, there are other distinctions, which I'll pass to in a moment. In this given case, we are dealing with a statute which on its very face thrusts itself into the First Amendment. We are dealing in this situation not with an address to an evil from which we must move back to a possible restraint upon First Amendment, but we are dealing with an entry particularly into the right and then a prescription upon the right as it might engender an evil. For instance, the statute itself starts off, "No person shall by word of mouth or writing advocate or teach the duty," and goes on from that point. It denotes First Amendment, here we come. It does not say that no person shall not advocate or teach the duty and necessity or propriety of crime. It does not then become so broad that it could possibly take symbolic acts or acting out that go beyond mere words of mouth and printing. It announces boldly, "Here we come, First Amendment," and proceeds from that point on. Advocate or teach. Now, the prosecution in this case has said that the issue of teach is not involved here because the man was charged only under advocacy. But if the distinctions between teaching and advocacy were so simplistic, we would have a very simple solution in this case. But as a teacher who teaches in the first grade that the American Revolution was a noble thing, is she merely teaching or is she advocating? The lines of demarcation between teaching and advocacy are so difficult that they leave us vulnerable when we charge advocacy alone. In order to reserve a portion of my time for rebuttal, I would like to point out, however, what I think is the most absurd aspect of this particular statute. It also forbids not only speech or printing. It becomes very, very evasive on the whole question of intent, scienter, and mens rea. Read it carefully. It becomes very, very unclear on the whole area of willfulness, except for an occasional phrase in its multiplicity of phrases. In addition to which, it forbids the assembly with any group. And it forbids not only membership, a problem that has been before this court, not only affiliation, a problem in this court, but indeed even forbids sitting down with such a group. In an era in which we are trying to preserve the dialogue benefits to society of the First Amendment, it is incredible that the legislature of Ohio forbids us even to sit down.
Well, I gather, Mr. Brown, that apart from your argument addressed to the statute itself, divorced from the actual prosecution here, you do argue, don't you, that the First Amendment considerations are so close to the surface in a prosecution under such a statute that at the very least it required an instruction which was not given here.
That is correct.
Which recognized of. And if we agree with you on that score, I gather we don't have to reach the question of the constitutionality of the statute itself, do we? You'd rather we did, but...
I certainly would prefer that you did. However,
but we don't have to if we strike it down in instruction, do we?
This court could potentially strike this down, not merely on the instruction, but indeed on the face of the record that it is not constitutionally sufficient to constitute an offense.
You mean on the evidence?
On the evidence. This court has those alternatives. I cannot escape.
What do you say to the...
However, I offer this posture. That the defendant in this cause asserted that he was not triable by a motion to quash the indictment, and that this court perhaps must assume his posture and find that he should never have been brought to trial, and that under those circumstances...
I know, but what's before us is the conviction, isn't it?
What's before you is
And if
the
we
entire record.
reverse
I
the
cannot
conviction,
escape that.
if we reverse the conviction, I take it that's as much as you're entitled to, isn't it?
I'd hope for more, but that's
I know.
all I'm going to be entitled to.
I wonder what you say to this statement on page 6 of your brief.
This is our brief, Your Honor.
Of your brief, that we are marching on Congress July 4th, 400,000 strong. That seems to tie this group into a rather big national movement.
May it please the court, let me say several things
And
concerning
then they go on and they say the Jews should go back to Israel and the blacks should go back to Africa. The program seems to be pretty clear.
How do we know this is a program? How do we know that
I mean,
this
just
is...
saying, from if you believe what they say, what the speaker says.
If you believe what the speaker says, this absurd hyperbole is a program. However, the program is a program of ostensible social reform, but does not necessarily indicate on the face of his remarks an intent to violence or to commit a crime. I agree with the court. It is absurd.
How else are you going to persuade some people to go back to Africa without violence?
I assume that he is offering this. I agree that we are operating with an absurd premise. Indeed, the absurdity itself may mitigate against the clear and present danger. But let us assume that he means by this that we will now bring pressure upon Congress to repeal the 14th Amendment and to pass an amendment saying the persons of certain ethnic background are no longer eligible for citizenship in the United States. He may be calling upon absurd, horrible, frightful, possible processes of law, but they might still, nevertheless, be processes of law. There is nothing in his statement that indicates he is
Not to
calling
get
for
some
this by
people to go back to Africa. You're going to need more than to change the law.
I'm afraid that if such law were passed, it might very well leave us in the position, Justice Marshall, of finding that perhaps under certain circumstances it is necessary to advocate violence to redress abuses of law.
Mr. Brown, before you sit down, I've inquired of our clerk as to whether or not the film is here. He advises me that it is not here. Would you just tell us what efforts you made to get it here?
Certainly. Upon the filing of this matter, I went to the clerk of the Supreme Court and ordered a transcript of the entire record. The clerk of the Supreme Court indicated to me that since cert was not allowed, that portions of the record were still with the Court of Appeals. I went to the clerk of the Court of Appeals and ordered from him an entire record, specifically in my precipice, asking for the film. We then actually engaged in physical search for the film. It had last been in the possession of Sheriff Dan Tehan. Dan Tehan went to his safe and couldn't find it, but the clerk then shipped up the entire remainder of the record and indicated to me he would continue the search for the film and upon receipt of the same would forward it to this court. I have not checked further. I will, upon my return to Cincinnati, immediately check further with the court.
Well, maybe counsel could answer it better than you could.
Mr. Brown, we don't have anywhere a complete transcript of what was said in the film either, do we?
Yes, you do.
Where is that?
In the appendix, on pages
24 and 25?
24 and 25.
Is that all? That's not all that was said because...
Then there is a second portion on the second
No,
film.
I mean to say, is there anywhere where we can look and see what's in that film from the first word to the last word? It's one thing to read these things, excerpts taken here and there. It's not maybe quite another thing to read it consecutively. Does that appear anywhere?
Yes, in
Where?
the appellant's brief.
Where?
On pages 5 and 6.
Now, is that...
describes in full the one film and then, in effect, synopsizes the second film. I believe that there is no dispute as to the content of the second film.
You mean, on pages 5 and 6, can we read that? And after we read that, do we have the full text of the transcript of the film, beginning with the first word and ending with the last word?
Of one entire film.
Now what about...
There are two films.
All right, now how about
the second film is indoors, is basically the same as the speech made, the speech portion of the first film. The man apparently repeated basically the same words with some emanations, some additions. These emanations and additions are substituted, are indicated in the brief, and both the prosecution and defense agree that this is an accurate statement of the second film. The only questions are concerning the first film. That's right.
Mr. Kirshner, would you mind stating, if you can, why the film itself is not here, if it's as important as Mr. Brown has stated?
Mr. Chief Justice and honorable members of this court, I do not know why the film is not here at the present time. I do know that I did know where it was as of 2 months ago. I viewed it subsequent to the Supreme Court of Ohio hearings, and it's in the clerk's office of the clerk of the Hamilton County Court of Common Pleas in his possession, locked up in a file, fireproof file, I might add, and I don't know why it is not here. I'm certain that it can be forwarded to this court for examination.
In all events, would you see that is done?
I will endeavor to follow through on the court's request. The court's permission, as I take it, basically, there are 2 points involved in this case. One is the Ohio statute on criminal syndicalism, and 2, the evidence that was presented to a judge and jury upon which a finding and verdict of guilty was returned. Now, counsel, I believe that the Ohio criminal syndicalism law is constitutional. I have cited various authorities relative to my beliefs in this matter in my brief. I believe that the basic matter before this court is the application of the evidence as was presented to the jury to determine whether or not there was sufficient evidence upon which a jury could return a verdict. I believe that in this case, when counsel says sending the Jews back to Israel, let's give them back to the dark garden, that this might not involve violence, I would like him perhaps in his reply to explain how the statement, "bury the niggers," quote unquote, would not constitute a violent form of action. Now, in this case, there is 2 basic parts of the film. One that was taken inside of a room in which the defendant, Clarence Brandenburg, was identified, and I don't believe there is any question in the record either between the appellant and the appellee in this matter relative to his identification as he being the person saying, "This is an organizers meeting. We have had quite a few members here today, we have had hundreds of members throughout the state," and so forth. Then there is a second portion of the film in which a group of people are walking or marching around a burning cross, hooded, armed, shouting profanities, in which there is a question whether or not the defendant himself said the words as attributed to him in the transcript and on page 5. How far is the nigger going to, yea, send the Jews back to Israel, and so forth with the other profanities. There is some evidence in the transcript itself which could indicate, as a jury sitting and listening in, that the defendant himself made one or more of these statements. And I apologize to the court for not having this as part of my brief. I notified counsel of the possibility of my bringing this matter up Ohio has a section in its code, Ohio Revised Code Section 1.17, which provides, whoever aids, abets, any person who aids, abets, or procures another to commit an offense may be prosecuted as if he were the principal offender. We have a group of people marching around as an organizer's meeting toward the acts of violence and end that they had attributed and desired, the suppression of the Negro.
What was the size of this group of people?
With the court's permission, at the time of the marching around the cross, the size was approximately 10 to 20, as counsel for appellant has stated.
Well, is
Prior to
there
that,
anything in the record that shows that more people were involved?
yes, sir, I believe that the defendant's own statement, we have had in his statement when he's inside the building, we have had quite a few members here today which are, and then he goes on to say, showing that there had been several members there. I might further point out that as one of the justices, I believe it was Justice...
Before or after he said he was going to bring 400,000 people to the district?
I'm sorry?
Was that before or after he said he was going to bring all these thousands down to the district?
That was just before that. That is the preface to the opening of that statement. Yes, sir.
Anything else in the record to show that there was any possibility of him carrying out any of these things?
Well, if Your Honor please, I believe that we have to take the entire actions of the defendant himself, that we cannot limit it to just what these words say. I believe the evidence clearly shows that the defendant himself contacted the television station for the purpose of having a television cameraman and newsman out at that meeting to take pictures to put it out over the television station. So when we say there are 10 or 20 people at this meeting, I don't think we can limit ourselves to just those 10 or 20 people. This is a plan, a concerted action on the part of this defendant to broadcast this, as it appears to me, and upon which a jury could determine this profanities, whatever you would want to call it, across a large segment of the community in Ohio. And subsequently, I might add, it was picked up by a network television. I don't think we can limit ourselves to just the 10 or 20 people. Although in and of itself, I would say that the statement such as this to 10 or 20 people, 10 or 20 people can cause one heck of a lot of crime and violence and terrorism in any community. It only takes one person to cause it. But you get 10 or 20 with hoods, shotguns, rifles, and other things, saying, kill the nigger, send the Jews back to Israel, send the dark man back to Africa, etc., riding in a community. And I say you can cause violence, crime, and terrorism right at the start with just two men, not 10 or 20 as the record indicates.
Well, out in the country. Out in the country.
Well, but the broadcast was not in the country. The broadcast was to the community, locally.
Except, Mr. Kirshner, the theory of the indictment, as I read it on page 2 of the appendix, is that these people were charged with violating the statute by what they did at that farm on 2 Mile Road on that evening, not with anything to do with the television broadcast.
Well, as a
Have
part...
I misread the indictment?
No, I would say that perhaps my interpretation of it is different from Your Honor's. As part of that meeting, this man had set up, right then and there, a television cameraman. His acts at that meeting were addressing not only the people who were standing in front of him, but the vast audience of the community who would receive this broadcast by way of the television communication, which he himself has arranged and which the record shows that he was the one that contacted the television station to get them there in the first place. So I would say, yes, his acts at the scene, but I don't think you can limit it to just the 10 or 20 people who were there.
Part of his acts at the scene, you say, were saying things knowing that they would be filmed and broadcast.
That is correct, Your Honor. That is my opinion.
That's my next point.
What were the elements of the offense as given to the jury by the judge's instruction?
With the court's permission, the elements of the offense, as given by the court's instruction in this matter, were basically that they shall the reading of the indictment and the definition of the word advocacy as pronounced by the statute of Ohio. The definition of advocacy is spelled out in the code section, and I believe, without giving specific verbiage, it is spelled out in the appendix. It is basically that aspect that was spelled out in this matter.
And instructions is to clear and present danger.
With the court's permission in this matter, there were no instructions relative to clear and present danger given by the court.
Or is it advocacy of action?
With the court's permission in the determination as to a specific spelling out item by item of advocacy of action, no. As to a general interpretation, I believe, yes. I believe the Ohio Code in its definition does interpret advocacy of action. It is advocacy of action of crime, violence, terrorism, not an abstract doctrine. It is the advocacy of the action to do violence, to do terrorism. And with regard to that matter, with the court's permission, as I spelled out in my brief, Ohio has a rule that an error of omission is not an error in the charge. I want to point out further that counsel for the appellant, giving him the benefit of the doubt, inadvertently left out that aspect of the charge in which the court turned to the defense counsel and specifically asked defendant's attorney, do you have anything to add to my charge? To which at that point, defense counsel says, and I may be getting not quite the exact verbiage, no, Your Honor, we are satisfied.
What page is this?
With the court's permission, that is not in the appendix. However, I have spelled it out in my brief itself.
Page 5 of your brief.
Page 5, if Your Honor, please. This is spelled out in the transcript on page 219 of the actual transcript. The question, counsel for the state, anything to add to the court's charge? Mr. Nicklin, who was counsel for the state, nothing, Your Honor. The court, counsel for the defending, anything to add to the court's charge? Mr. Alcott, counsel for the defendant, no, Your Honor. This is at page 219 of the transcript, and it's spelled out on page 5.
I gather these constitutional questions were raised on the appeal or whatever that procedure is that goes to your Supreme Court, were they?
With the court's permission, the constitutional issue relative to the aspect of clear and present danger was raised in the...
Well, then may I ask this question?
Was raised where?
I believe it was raised in the Supreme Court of Ohio. I took the case on at that level. I was not the trial counsel, nor was I the appellate counsel.
Well, then may I ask, Mr. Keshe, I'm looking at page 85, which is the judgment of the Supreme Court of Ohio. What does this mean? It says, the cause here on appeal as of right was heard in the manner prescribed by law, and no motion to dismiss the appeal having been filed, the court, that is the Supreme Court, sua sponte, dismisses the appeal for the reason that no substantial constitutional question exists herein. Do I read this correctly if I suppose this means that they examined the record to see if any of the constitutional questions asserted were substantial?
Let me give this aspect. I cannot speak for the Supreme Court of Ohio as to their interpretation of verbiage. I can give this court procedure. The procedure in this matter is defense counsel filed his appeal within time and as of right. At that point, defense counsel and the state appeared in Columbus, Ohio, at which time the court, through its representative, heard arguments both for and against the allowing and the constitutional question by the Ohio Supreme Court at that point. Subsequent to that, the court then issued this ruling.
Well, doesn't this suggest that whatever the constitutional questions that were raised, and I gather you tell me the clear and present danger was among them, was considered and decided?
Yes, sir.
Well, if that's so, what difference does it make that no objection was taken to the charge? If your Supreme Court reached and decided these questions, then they're properly here if they overlook the failure to take objection.
Well, if Your Honor please, what I am saying is this. The charge that the court gave, insofar as it went, was not incorrect. I am saying further that the absence of the verbiage clear and present danger did not make that charge void. I am saying...
Suppose we disagreed with that. Problem is,
Your
if we disagree with that, whether we can reach it in face of the fact that there was no objection. And as I gather from this judgment of the Supreme Court of Ohio, it considered and decided the constitutional question, and I suppose in that circumstance it's immaterial.
I would say that if you disagreed with the basic premise that it is the duty of counsel to raise that objection at the time, and that the law of Ohio is incorrect.
We disagree with the basic premise. It is that that was not given as a reason by the Supreme Court of Ohio not to decide the merits of the constitutional claim. On the contrary, the Supreme Court of Ohio apparently did consider and decide the constitutional questions, notwithstanding the failure to make objections. And if that's so, I think, isn't it so that the issue then is properly before us?
Well, with the court's permission, as I have indicated, it is my humble belief that this is basically a state statute. If you determine the state statute is valid, you go to the evidence. And I believe that the evidence was there, and the only way that it should be thrown out is if there was no evidence upon which a jury could have reached this finding, because the court's charge that was given was specific enough and direct enough to cover the clear and present danger, to cover all of the other aspects of the case.
I take it that the state's position is that the advocacy in the form that it took, demonstrated by this film, constitutes a violation of the Criminal Syndicalism Act. Is that right?
I believe that the advocacy at the scene, which was to be said to the members there, as well as the advocacy which was planned to go out over the television network, constituted a violation of the Ohio criminal syndicalism laws insofar as the indictment charged violence or unlawful methods of terrorism.
Well, if that's so, were the people, were the network people, to use that vague phrase, violating your law too?
With due respect to the court, in my humble opinion, I believe that the network people, in working with this advocacy, there has to be an intention. If it can be shown that they intentionally put this out over the television networks with the thought of bringing violence or terrorism, then it is my humble belief that they may be indicted the same as Clarence Brandenburg was in this case in violation of the Ohio laws.
Well, is there any evidence in here other than the film itself and the network arrangements that Mr. Brandenburg intended to bring about violence?
The court, please, I believe that the court and the jury may look to the words itself, the surrounding aspects. As Your Honor, in a reference that you recently wrote on civil disobedience and civil disorder stated, even if what is said does not create a clear and present danger, and I believe that it was a clear and present danger at the time, a physical injury to others, the place where the speech is uttered, the size of the crowd, and the circumstances may convert the lawful into the unlawful. It is my humble belief that the circumstances, if this was on a rural farm where nobody was around, nobody would hear this except perhaps 5 people in a little circle. And Clarence Brandenburg was never tied in, the defendant in this case, to the propagation of this epithets, derogatory statements, or call them what you may, through the television networks. I say that the state of Ohio's case would be substantially weakened. But in this case, it is not someone else contacting the television networks. It is Clarence Brandenburg himself who contacts the television newsman himself, requesting that they have a man there to take his picture, making certain statements, and to take his group, of which he is the leader and organizer of, in propagating these statements to the general public of the Cincinnati community.
I suppose it can be said that there's no question that he intended to advocate whatever he advocated here. But the next question is, do you have to have some additional proof to the effect that he also intended that steps be taken to carry out this program with respect to the Negroes and the Jews and so on that he described.
Well, with the court's permission, it is my humble belief that you do not have to have anything further. If I were to go, and I use this as an extreme statement, but if I were to run down Harlem, shall we say, and say, bury the Negro, send them back to Black Africa.
You wouldn't last that long.
Probably so, Your Honor. And if I were to go to Israel and say the same thing about sending the Jews to the Arab countries or something, or to any other, I don't say that derogatory, but I say that because these are the two groups that the defendant has picked upon in his derogatory statements. I say the very words themselves indicate...
Those words were carried on the network. Why wasn't that a violation of your law? That's the question I started with.
As I indicated with the court's permission, it is my humble belief that in addition there must be an intention to cause the violence,
That's right.
terrorism.
And I ask you again whether there's any proof of that other than the utterance of the words and the arrangement for the network.
Other than the defendant's actions, which I believe indicate his intention, there is no other proof.
Mr. Kirshner, this was in June of 1964, this
Yes,
meeting?
Your Honor.
June 28th, 1964.
Yes, sir.
What was the contemporary context in the Cincinnati community? Those riots in Avondale came in the spring of 1966, didn't they?
I believe it was 66 and 67, if I'm not mistaken, and 68.
But now
however,
you've
there was at the time unrest. There was marches at the time, I believe, in the South. There were the propositions, specifically, I believe, the Birmingham situation was at or around that particular time. And there was civil unrest and dispute going out through the entire country. And I don't think it'd be just limited to the South as such. It was played up by the press and the news media.
But there was no particular local situation in Hamilton County at that time, was
As to riots,
there?
no.
Or that kind of unrest, racial unrest,
I believe that there
in any
was...
dramatic form at that time.
There were there were protests marched within the concepts of legal protest, demonstrations, picketing of that nature at that time in Cincinnati, but in the nature of riots of that nature, no, Your Honor.
This was not part and parcel or a response to anything specifically that was going on in that community at that time?
No, sir. It was basically a feeling, I believe, throughout the entire United States, however limited as such to the community. Thank you.
Mr. Brown, may I don't suppose that whatever it is you and Mr. Kirshner submitted to
The Supreme Court of Ohio is in the record before us yet, is it?
In view of the fact, Your Honor, of the amazing circumstance, in my opinion, that I did not get allowance into the Supreme Court of Ohio, I, in ordering my certification of record to this court, asked specifically that the briefs submitted to the Supreme Court of Ohio...
So they're probably
So
here.
they are within the possession of the clerk here.
Have you any recollection whether the state raised the question of failure to object to the instructions as one reason that the issue should not be...
The state has not, until we appeared here, if I'm correct, ever raised any question of failing to object.
Now, how do you interpret that judgment of the Supreme Court of Ohio?
May it please the court. If the court is aware of the procedures and the entries of the Supreme Court of Ohio, the Supreme Court of Ohio, if it is ruling that a constitutional question has not been raised, will deny the motion to dismiss the appeal as of right, with the following language. A constitutional question having not been timely raised, the same is dismissed. If the constitutional question has been properly raised, it will use the language in the entry before you.
I see. So that's to say then, in your view, that judgment should be
considered
read as a determination on the merits of the
That's
constitutional
correct.
question.
Now,
That's just boilerplate in the Supreme Court of Ohio, isn't it? That's this form on page 85 of the
that's
appendix.
boilerplate form when they're just turning it away on the merits on the substantive constitutional question.
You mentioned in your brief, I think, Mr. Brown, that the reason there was no opinion in the Court of Appeals of Ohio was that the judge assigned to write the opinion died?
Judge Hover, who you know.
Yes. Does that appear does that fact appear anywhere?
No. That was told to me by Judge Law.
I see.
It would not appear in the official record.
Was this Cassie case back in 1932 the one that Judge Florence Allen wrote quite an eloquent dissent in? Do you happen to remember? Well,
I don't remember a dissent at all. I don't remember a dissent. I know it was a 5-2 vote with 2 dissenters, but I don't remember any written dissent.
Perhaps I'm thinking about a different case.
In Ohio, does everybody know who's been assigned an opinion to write?
No, it was only in this instance, Your Honor, that there had been approximately a year's delay after the submission to the appellate court. We then approached the appellate court asking why, and at that time the judge informally indicated that the man who had been assigned the opinion had recently, unfortunately, died. And that's how that came to light.
What was the sentence in this case?
The sentence was 1 to 10 years.
On each count?
On each count. And a $1,000 fine on both counts.
Concurrent?
Concurrent, yes.
So that...
So this man could potentially, for this act of stupidity, serve under the laws of Ohio up to 10 years maximum.
Well, to win your case, you don't have to demonstrate that it's just stupidity.
No, to win my case, Justice Fortas, may I submit that the state of Ohio has just at this moment indicated the massive invasion into the First Amendment that we have here when Mr. Kirshner suggested that I could run down through Harlem saying, kill the Negroes, and Justice Marshall responded, you wouldn't last very long, that Justice Marshall, who is safe at the moment because the venue is in Washington, D.C., but in Ohio, could be indicted for suggesting a violent reaction by the Negro community. This is the state of the invasion under this statute into the First Amendment rights. Because under the proposition that Mr. Kirshner outlined here legally, that is precisely the effect of Justice Marshall's remark. I suggest further that we have this unusual situation. We have such a deep-seated invasion of the First Amendment rights that we get enmeshed in the difficulties that Mr. Kirshner outlines when he says there was no objection. Incidentally, I was not counsel of record, and I have never at this point, because I feel certain professional loyalties, raised the question of competency of counsel in the original trial. But assuming Mr. Kirshner's reasoning, what he has stated here is that the Supreme Court, with the state of the record before it, was saying in effect that a constitutional issue is a mere error of omission. And it is further saying that the instructions that you have before you to read are the dimensions that Ohio sets upon this statute's invasion of the First Amendment. And I suggest that if that is the state of the record, that perhaps my earlier response to you, Justice Brennan, is not correct. That perhaps we must then reach the statute and declare it unconstitutional.
Mr. Brown, before we conclude, I'd just like to say to you that the court appreciates your acceptance of our assignment to represent this indigent defendant. We consider that a real public service, and we're grateful to you for your effort.
I should perhaps state for the sake of the record that counsel for the appellant in no way agrees with any of the appellant's positions. I will, however, take the Voltairean position in relation to the appellant.
And Mr. Kirchner, we, of course, appreciate your fair and diligent representation of the people of Ohio.
Thank you.
We'll adjourn.